Well, former President Jacob Zuma has launched an application before the Constitutional Court now to have the 6 judges that presided over his contempt of court matter to recuse themselves from the IEC MK party matter. Let's get more analysis by welcoming legal analyst Mr. Melusi Xulu. Melusi, a very good afternoon to you. Always good to have you with us. So talk to us about this process. What exactly are the chances of the success of this recusal application?
Good afternoon to you, Machali, and to the viewers at home. Thank you for having me. Well, the chances of success will depend whether the 6 justices or judges that the former president is saying must recuse themselves do understand his nature of concern, and they do understand that there is an apprehension of bias or conflict of interest on their part. That is, it depends if they will understand it from a legal standpoint. However, they can also deny to recuse themselves. But just to paint the picture, if you will allow me for a second, the question is this: like, if any natural citizen of the country says, look, the judges that have convicted me in what I believe was an unlawful way of doing so, and sentenced me without having a trial, without having a docket, and I also did not have my right to appeal, which is a constitutional right itself. If you go to section 35, subsection 3, paragraph O. So if you are that person, and those particular justices now have to decide whether their decision was right or wrong, that is basically what the former president is concerned about, that this could not be the people that could decide on this constitutional matter, because they were the ones, as a court of first instance, who sentenced me, which is something that was unusual. This is his standpoint.
I mean, let's expand on that point, Melusi. I mean, he says, he cited there, I think you mentioned it, he said he cited potential bias by these 6 judges. But what would then, what type of tangible evidence would the former president need in order to prove this bias?
Well, he needs to prove that, based on a reasonable person's position, that these former justices, what they did was, something that could lead to them deciding on their own decision, because they're the one that decided that he should be convicted and sentenced as a court of first instance, which is something that is unusual. But now they also have to decide whether that decision was correct or not, because they didn't even give him a right of appeal. So he's saying this could not be the right people, because I did not agree with how they sentenced me, and I do not think they should be the ones to decide or to analyze or make a decision on their decision, which I feel was unconstitutional, which could lead to the matter not being heard because of the quorum, which is based on the Constitution as well.
All right. And then, Melusi, we understand that a minimum of 6 judges, right, is just not fit to adjudicate the matter between Zuma as well as the IEC, right? But what are then the rules as well as the process of such a request? And also looking at the timing, I mean, we're less than 3 weeks away from the election. Can then these 6 judges be simply replaced and the case proceeds and the ruling is made?
Well, the initial step is this: if they will be recused, based on section 167, subsection 2 of the Constitution, it means that at least there will be no 8 justices to decide on the matter. So it will depend how fast they can get acting justices to assist in this matter. But like you said, there are about 3 or 4 weeks left, and it's it's an urgent matter. But that's not what Zuma or the former president is concerned about. He's just saying these are not the right people and they must recuse themselves. Whatever decision is made on their replacement, this is not his concern. He's just concerned that this could not be the right justices to decide on the matter, because he believes that they made an unjust decision to convict him. But remember that Justice Theron she made a minority judgment. She did not agree with the majority judgment.
And very interesting, right, Melusi, that the current CJ, the Chief Justice Zondo, is also on that list of 6. So, I mean, was this to be expected in your view, seeing how the initial case of Zuma's contempt was actually handled? And I think when the IEC case actually started and we're waiting a ruling, I actually alluded to this, that might we expect an application for recusal? And here it is. And maybe just also help us recap on Section 47 1E as well as 19.3b.
Yeah, well, Section 47, subsection 1E, again, it says if a person wants to be part of a national parliament, and they cannot be, it can be objected if they have a sentence of 12 months or more.
Yes.
And basically, it also says that if that person is appealing or has a process of appeal that has not expired, it's not related to them. So in this instance, the former president, as the electoral court decided, this does not apply to him because in any case he could not appeal with this particular judgment. You know, which I think this was expected that he might have a consent, because I did say on one of the platforms that the next question that we'll have is, did the justices, the majority judgment, although they made the majority judgment, did they make the right decision to convict him and sentence him as a court of first instance? Because now it can't be appealed. And that is a constitutional right, that is the one that I mentioned. Then to Section 19, subsection 3, paragraph B, basically says everyone has a right to, stand for a political office, which is a constitutional right. So what the electoral court tried to do was to harmonize the two provisions that I just mentioned. But to answer your first question, this was kind of expected, because we know how, the former president, he makes sure that he exhausts all the rights that he needs to exhaust, and he will appeal and appeal. So this kind of innovation was expected, but also in any case, it's his constitutional right to do so. So let's see what the justices will decide, whether they will say they deny the recusal application or they'll recuse themselves. It will be very interesting to see what they'll decide.
So very interesting as well, Melusi, very quickly before I let you go. So should the justices, right, that are part of that 6 actually refuse to recuse themselves, what then is the likely outcome of this whole debacle?
Well, if they refuse to recuse themselves, they'll continue to hear the matter, and they'll then have to decide whether the conviction and the sentence that they made in 2021 is in line with Section 47, subsection 1, paragraph E, which I do agree with the judges in the electoral courts, the 3 of them that decided that is not in line. But we will see whether they will be the right people to do so, because they're the ones that convicted him. Because in a way, indirectly speaking, the judges at the electoral court may be saying in a respectful manner that judgment that was made in 2021 was an unconstitutional judgment, because, it could not be appealed. Although they did not place it in such ways, they just said it's not in line with Section 47, subsection 1, paragraph E. But why would the judgment in a constitutional court not be in line with the constitutional provision, But let's see how they'll decide. But hopefully the right decision will be made, because it's a very contentious elections. And I hope the political parties will, be able to sensitize their followers. But the right decisions must be made, and the Constitution must be upheld by the justices and everyone that is involved.
Oh, very informative. Thank you so much to you. Of course, our legal analyst there, Mr. Melusi Xulu. And of course, he was just giving us some more clarity on the issue of course, we've just heard that the former president, Jacob Zuma, is actually seeking an application to have the 6 judges that ruled in his contempt matter in court, as of course, he wants them to be recused.